Hey everybody, Broker Jimmy here. Wanted to clarify some stuff about the Sherman Antitrust Act of 1890 today. I am the broker for North Florida Real Estate Partners. I'm also the lead instructor for North Florida Real Estate School. Love to talk to you about this issue because ever since the NAR lawsuit came out and everybody's been worried about these decoupled commissions from the summer where the buyer pays their portion and the seller pays their portion, we've had a lot of uncertainty. People are scared of doing certain things like posting their commissions that they're offering on social media, on the internet. You're allowed to do that. You're not allowed to post it on the MLS because that's a NAR rule. It's not a federal law, okay? We want to make sure we separate those, right? NAR has their rules, and if we use their platform, we have to abide by their rules. Federal law says we can do other things. So what the Sherman antitrust law did is said we can't fix commissions. We can't fix market areas. We cannot conspire to get commissions higher than what the market should pay us, right? So what we don't do is tell people we have a normal rate, tell people we have a standard rate. We're not allowed to communicate that. We're not allowed to conspire with other brokerages and say, hey, I'm charging 3%, you should charge 3%. Now, I can tell you, when I worked for a big brokerage 20 years ago, they did tell us in meetings, you can only charge a minimum of X number of dollars. Well, that's not right, and that's not legal, right? So what we want to do is understand the difference here, where the buyer-broker agreement says how much we're allowed to be paid, right? So if you negotiate a 3% commission with your buyer, then that's all you get paid. So if a builder offers 3% plus a percent bonus or a $2,500 kicker or whatever you want to call it, you can't get paid that if your buyer's not aware of it and has signed off on it prior to you going to contract, right? So understand that if a builder goes on social media and says, hey, I'm going to offer a minimum of $20,000 commission on every single one of my deals for the next 60 days, that's perfectly legal, right? The thing is they can't pay it to you if your buyer-broker agreement also doesn't line up with what they're paying. So just to clarify, it's not illegal to post this stuff. There's websites out there designated just to post commissions. There is social media posts. You can pick up the phone and call them. We're allowed to communicate that because we need to know what we're being compensated, and we need to know if we need to act accordingly. Do we need to ask the seller to pay 0.5%, for example? Do we need to have our buyer-broker agreement amended because the buyer can't afford to pay that extra 0.5%, just for example, right? So understand that it has nothing to do with posting on social media. This whole lawsuit has to do with the decoupling of commissions and disclosing everything to the public. So when somebody calls me and says, hey, I've been told that I'm not allowed to do this, that really is concerning to me because this person is misinformed, and they need to really speak with their company to find out what their policy is, but understand what NAR's rules are and what federal law says, because it's two different things. So I hope that helps clarify everything. My number is 904-477-4005. I'd love to talk to you about real estate, get you in one of my licensing classes, and help you get started in your career. Have a great day.